Good morning, sir. Can you see and hear me?
Yes, I can.
Thank you. Can I call Mr. Stapel, please?
Yeah.
Thank you.
I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth.
Thank you very much. Can you give your full name, please?
Yes, my name's Debbie Stapel.
Thank you, Ms. Stapel. You should have in front of you a witness statement dated the 15th of October 2023. It should be in the first of the bundles in front of you behind, I think, tab A.
Yes, it
Yes,
is.
thank you. Could I ask you to turn to page 38 of that statement, please?
Yeah,
Can you confirm that that's your signature?
yes, it is.
Thank you. And is that statement true to the best of your knowledge and belief?
Yes, it is, save that I omitted simply because I'd forgotten that prior to joining the criminal law team, I worked for the CPS for 4 months,
And that was at Maidstone?
and that was at Maidstone.
Thank you very much. That witness statement has the URN WITN 089000100. That statement will go into evidence and it will be published on the inquiry's website. The questions I'm going to ask you today will be supplementary to that and will aim to clarify a few matters and seek further information where appropriate. You qualified as a barrister and were called to the bar in 1987, is that correct?
That's correct.
And as you say, there was a brief period, I think, in private practice and then working for the CPS. But soon after, 1989, you joined the Post Office criminal law team.
That's correct.
I think we'll see your name on a number of documents. In your maiden name, is that correct?
That's correct.
And what was that?
That was Debbie Hellshine.
Thank you very much. In 1997, I think you took maternity leave, followed by a very short career break, and returned in 2001. Is that correct?
That's correct.
Between 2001 and 2006, you worked on what you've referred to in your statement as counter cases and letter cases. Counter cases being cases that involve Crown Office employees, sub-postmasters and their assistants. Letter cases involving postmen and postal packets and things like that. Is that correct?
That's correct.
And I think you've said that you largely stopped being involved in counter cases in 2006, except for the case of Carl Page, which is a case that we're going to come to today.
That's
is that
correct.
right? Thank you. You left the post office in 2013.
I did.
And I think you left to run a hotel, which you still continue to run now. Is that correct?
That's correct.
Having come back from maternity leave and a career break in 2001, so that was shortly after the rollout of Horizon, do you recall any significant changes in prosecutorial policies or training on your return?
On my return, as I recall it, the cases that were being submitted for advice were still very much the old-style cases involving, on the whole, pension allowance overclaims or inflation. But obviously, with the rollout, things were going to radically change, or at least they were going to change once the pension allowances stopped, which I think was in 2003. I know that I wasn't involved in it, but I know that Mr. Heath was obviously involved in looking into how prosecutions could continue.
In terms of the policies that were followed within the criminal law team and the training that was involved, that was provided to lawyers within that team, did anything significantly change once Horizon had been rolled out?
No, we had a day's Horizon training, but other than that, no.
Had you been told of any issues with Horizon?
Absolutely not. We were told that it was effectively this super system. There was certainly no indication that there were any problems with it.
Thank you. Ms. Stapel, your speed is perfect. Your volume could do with being raised slightly if
I'm
possible.
sorry.
Thank you very much. You may need to just speak slightly closer to the microphone. Teresa Williamson has described a lack of collaboration within the criminal law team, a lack of sharing of knowledge, for example. Was that your experience, or did you have a different experience?
It depends on what you mean by sharing of knowledge. If anyone had had a case that had involved a bug or a defect, then that would have been flagged up to, or it should have been flagged up to Mr. Wilson. And we did have team meetings. I think they varied between once a fortnight, once a month, where any issues of concern would be raised. And I think on a day-to-day basis, lawyers would discuss cases, not every day, but if you had something unusual, or if you were considering the public interest test and wanted a second opinion, you'll discuss it with another lawyer.
Obviously, the words would have and should have are very different. When you speak about bugs, errors and defects, and that they would have been raised or should have been raised, which one is it and why?
Well, I would have hoped that they would have been raised. I think it was always clear that if there were any issues in a case, that they should be flagged up to the team leader. Sorry, not the team leader, the head of criminal law, so Mike Heath to begin with, and then Rob Wilson.
And did you experience that knowledge being shared?
Of
bugs, errors or defects?
Absolutely not.
I want to ask you about the code for Crown prosecutors. Both yourself and Miss Williamson's evidence has been that the code was the primary policy that was consulted within your team. And you've said it was followed at all times. Do you know if there was monitoring, or how can you be so certain that it was followed at all times? Or were you just talking about yourself?
I was talking about myself.
How was the code made available? Was it on the intranet, on people's desks?
No, we all had a copy of the code on our desk.
And when you say you all...
all the lawyers.
And that was something you saw around the office, was it?
Absolutely, yes.
Can you assist us with what were the key prosecutorial guides or rules that were available outside of the code for Crown prosecutors?
I'm not sure what you mean, sorry.
Were there any other policies that were regularly consulted?
No, not that I can recall.
Did you use the internal intranet to find policies, or?
So I don't know at what point this happened, but by the internal intranet, I presume you're referring to the corporate security database. So the corporate security database, in order to access it, you had to have a password. So initially, that was very much, the intranet was very much for security. So it wasn't something that legal services could add a document to. It was theirs. So there came a point that I know I asked for access to it, and we were all issued with passwords.
Are you able to assist us with what period that was?
I'm afraid I can't.
No. And did it contain useful documents for people in the criminal law team, or was it principally, as you said, a security?
It was principally a security thing. I wanted access on it. If there was an issue on a case in terms of something an investigator had done, to refer to the guidance on there to see whether it was clear, and whether, had they referred to it, they wouldn't have done what they'd done.
You talked about the code for Crown prosecutors. Was that on the intranet, or was that just something that you had in hard copy?
I just had it on hard copy.
That code, as we know, contains something called the full code test, which has two parts, an evidential stage and a public interest stage. Were you aware of any specific guidance or factors that needed to be considered at the public interest stage that were specific to the post office?
Specific to the post office?
Well, was there any specific guidance that addressed that public interest stage?
No.
I think
Or not that I can recall, I should say.
At paragraph 29 of your witness statement, you've said that it was usually health was a matter that was considered, or I think false accounting under £5,000. Was that just something that was known within the office? Was it something that was set out somewhere?
No, it was something that was agreed, I presume, at an office meeting.
And was that well known to all those who worked in the criminal law team?
Yes.
And was it principally those two factors?
Health and one of the other, well, I suppose it's ill health, but on a occasion a burglary would have been committed at an office, and that would be raised at interview, and those would be one of the circumstances in which I would send papers back to find out the impact it had had on the sub-postmistress or master, and also the circumstances, i.e. was violence used or...
So is that a case where you may have been prosecuting the sub-postmaster, but they themselves were a victim?
Absolutely.
And that may factor into the public interest?
Absolutely.
Thank you. I'm going to bring up our first document today. It's Poll 000-30659. It's a document that a witness has already been taken to quite recently. It's called the Post Office Internal Prosecution Policy Dishonesty. Your evidence in your statement is that this isn't a policy that would have been used by post office lawyers. Is that correct?
Absolutely not.
Is it something that you were aware of?
I think I'd seen it before. I was aware of it, yes, and I couldn't understand it because it doesn't make sense on a lot of levels in terms of what was prosecuted and what wasn't. I don't know why Andrew Wilson wrote it. I don't know who it was aimed at, but it's a muddle, and it certainly wasn't taken into account in making prosecution decisions.
I'll just read a few extracts from it, and please do assist me if there's anything in particular that you think is a muddle that I haven't read out, then please do say. Under 2, it says there's no single statement of current policy, but it can be summed up as normally to prosecute all breaches of the criminal law by employees which affect the post office and which involve dishonesty. And if we go over the page to page 3, if we scroll down slightly, another passage that I'm going to read out, in order to provide a deterrent and to serve the public interest, it's clearly necessary to prosecute offenders in the criminal category. Just pausing there, to what extent did deterrence come into play in prosecutorial decision-making?
I think deterrence probably came more into play in, if I can call them letters cases. Obviously, if, for example, you had a greetings card thief, it was important that postmen understood that if they stole mail or they didn't deal with mail correctly, then they risked prosecution. I think it was seen as a deterrent, but obviously that wasn't the sole criteria for prosecuting.
And if we look down at the bottom of page 3, it seems to attempt to formulate a prosecution policy as follows. The Post Office's policy is normally to prosecute those of its employees or agents who commit acts of dishonesty against the Post Office for the purpose of illegally acquiring post office property or assets, or the property or assets of post office customers and clients while in post office custody, where this is deemed to serve the public interest. Other wrongdoings will normally be dealt with via the discipline code. Is it that kind of thing that you're referring to as a bit of a muddle?
Yes, and also further up the document, there's reference to willful delay and intentional delay. Sorry, willful delay, which later became intentional delay, and I think there's mention of criminal damage. Obviously, neither of those are offences of dishonesty, but they were routinely prosecuted.
Thank you. I'm going to move on to identifying who the prosecution decision makers were. And I'd like to begin with your witness statement. Can we please bring up on screen WITN 089000100? And it's page 9, paragraph 23 that I would like to look at. Sir, I'm being told that there is an issue with a live broadcast on YouTube. I'm happy to proceed with the hearing, and perhaps that can just be fixed while we're proceeding, unless you would prefer it to be paused.
Well, no, my normal practice is to proceed unless there's likely to be such a substantial delay that members of the public or whoever else who's watching would really not get any idea of what's occurring. So what I'd like to do is to proceed, but if there's a real risk of a complete breakdown, so to speak, for me to be notified of that.
Thank you very much. Thank you. So if we have a look at paragraph 23, you say there, where the evidence was sufficient to afford a realistic prospect of success, and it was in the public interest for a prosecution to ensure the lawyer would advise appropriate charges, the file would then be returned to the casework manager, who would in turn forward it to the relevant person for authorization. Now, that relevant person, was that person a lawyer or a policy specialist or something else?
No, they weren't a lawyer. I can no longer recall what job they held.
If you or a member of your team had taken the view that the full code test wasn't met, for example, because of a suspect's health or something along those lines, would it still go to the nominated decision maker, or would that be a total bar to proceeding?
No, it would go to the casework manager and the papers would be closed.
So, in effect, was your assessment final in terms of the decision to prosecute, despite the fact that
it was?
Yes. If you had said that there was sufficient evidence and the full code test was met, would that ultimate decision maker, could they still take a different decision not to proceed?
They could put their reasons why they disagreed with the public interest part, which is what they were concerned with, and the papers would be returned to us and we would consider what they had said.
Did you experience or hear of cases where the lawyer had said that something was not in the public interest, but nevertheless the prosecution proceeded?
Sorry, can you say that again?
Did you hear of or experience any cases where the lawyer had said that something didn't meet the full test because of the public interest aspect of that test, but nevertheless the prosecution proceeded?
No.
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 Can you assist us with what level of oversight external counsel provided? So was counsel routinely instructed or occasionally instructed to advise on the evidential test, on the public interest test?
In rare cases, so in complex cases, they were instructed from the very beginning.
And would they advise on both aspects of the test, or was the public interest test something?
They would advise on both aspects.
Thank you very much. I'd like to look at a second document. It's POL 000311012. You'll have seen this document in your pack, and if we turn over the page, it's March 2000 document. Thank you very much. And if we go back to page 1, it's something called an investigation and prosecution policy. And if we could look at paragraph 3.3 and 3.4, I'll just read those. Paragraph 3.3 says, where evidence of crimes committed by a consignia employee against consignia or its customer is established, the offending employee may also be dealt with in accordance with criminal law. The prosecution guidelines of the business will be used in making any decision to proceed under criminal law in consultation with SIS. Just pausing there, do you know what SIS stood for?
Do you know what I did? But I can't remember. I've been trying to work it out. Senior. I'm sorry. I just can't recall. But I think it's someone senior in the investigations team.
And legal services, criminal law division where appropriate. And then it says the main consignia interface with other agencies, e.g. police, customs, Interpol, DSS, etc., is SIS. There are occasions where a SIS investigator or an investigator within the business unit will necessarily hand an offender into police custody. In these cases, the decision to instigate prosecution is made by SIS. So are we to understand from this, and perhaps your knowledge from subsequent policies, that the Legal Services Criminal Law Division was a division to be consulted, but was not in fact the ultimate decision maker in respect of whether to proceed or not?
That's correct.
Thank you, that can come down. I'm going to move on to your knowledge of the Horizon system. I think you've said you had a day's training, was it, on Horizon?
We had a day's training.
We've heard about ARQ data, and you've addressed it in your witness statement. How usual was it to obtain audit data in the form of ARQ data from Fujitsu?
It's actually quite difficult to answer because I really can't recall. It was obtained, but I really can't recall now how many cases that I had where it relied on a Horizon deficiency. I think there were very, very few. As I said, up until 2003, the cases in the main still related to pension and allowances. And after I started the case of Page and Whitehouse, I was allocated very few poll cases.
Are you able to assist us with whether it was rare, occasional, frequent for you to request ARQ data?
I think it was frequent, but in very few cases.
So you didn't have many cases that required it because I think you said they were not relating to deficiencies in
yeah, well,
Horizon?
I do know that, for example, in a pension allowance overclaim case, where, for example, the defence would say there wasn't a stop notice. Under Horizon, you would physically scan the book, and Horizon would tell you that it should be confiscated and the payment shouldn't be made. So I think ARC was used to show whether the book had been manually scanned, manually processed, or whether it had been scanned.
In respect of accounting figures that related to deficiencies, for example, was that something that discrepancies, was that something that you were involved in? We're going to go on to talk about 3 cases that you had some involvement in, but outside of those 3 cases, was that something that you did have some involvement in or not?
I can't recall.
What did you understand to be the limitations on obtaining that information from Fujitsu?
So I understood that that the contract hadn't been drawn up particularly well, and there was a limit on the amount of requests that could be made without additional costs being incurred. But as far as I'm aware, that was never, ever a consideration in whether such evidence should be obtained.
When you say it was never a consideration, do you mean it was never your consideration, or were you aware of other people routinely requesting that kind of information from Fujitsu?
Yes.
Yes, you were aware of people routinely requesting it from Fujitsu?
Yes, I was.
I'd like to look at paragraph 43 of your witness statement. It's page 17 of WITN 089000100. You say there, where the integrity of the Horizon IT system was being challenged, the investigator would be asked to obtain any relevant data/information from Fujitsu. At the time I conducted poll cases, I was unaware of any bugs or defects in the system and believed that Horizon was robust and a reliable system. Dr. Jenkins, and we're going to come on to talk about Gareth Jenkins, in his expert statement would have asserted that, and as an expert would have been under a duty to disclose any information that undermined the position. So you've said there that where the integrity of the Horizon IT system was being challenged, the investigator could obtain the relevant data from Fujitsu. Do you think it was fair to put the burden on a defendant to challenge the integrity of the Horizon IT system in order to trigger those?
So with what we know now, clearly not. At the time, I genuinely believed, and I don't think anyone in my department were aware, that this wasn't effectively the perfect operating system. I mean, my understanding was that the reason why and I realise this is wrong now, but my understanding was the reason why there was a rollout was to ensure that that A was the system that sub-postmasters could operate, and secondly, that there weren't any accounting problems as a result of it. In other words, that it was technically sound.
Can we also look at a slightly later paragraph in your witness statement? It's paragraph 56 on page 20. You say there, I cannot recall what the contractual requirements on Fujitsu were. I am aware that there were limits on the number of ARQ requests which could be made without additional costs being incurred. I do not know how any requests above the limits were dealt with or charged, but this would not have been a factor taken into consideration in deciding whether such documentation should be obtained. Now, the inquiry has heard evidence to the contrary in respect of a reluctance to seek ARQ data because of cost implications. Can you assist us with how it is that you can be so definitive on cost not being a factor that's taken into account?
Well, it may simply have been that it wasn't raised in any cases that I dealt with, but I would be surprised if it was something that that a lawyer asked for and thought was necessary, then that would be the end of it. If it wasn't obtained, then the case will be withdrawn.
Do you see any distinction between the lawyers and the investigators in that respect?
Sorry, in what sense?
Would you be aware if, for example, investigators were reluctant to obtain ARQ data?
I wouldn't be aware of that. I'd be surprised, but I wouldn't be aware of it.
Thank you. Thank you. Moving on to the topic of bugs, errors and defects, you've said in several places that you were unaware that there were bugs, errors or defects in Horizon. Were you aware of any messaging to the contrary, that there weren't integrity concerns? You've talked about an absence of knowledge of bugs, errors or defects, but were you aware of any messaging quite the opposite, that Horizon is a robust system and there are no integrity concerns.
Not that I can recall.
When did you first learn about bugs, errors and defects in Horizon?
From the papers.
When you say newspapers?
Newspapers.
And when was that? Was that from the group litigation, from the Court of Appeal, or earlier, Computer
Earlier.
Weekly?
Earlier.
Can you give us...
I can't. I'm sorry.
Did you see a panorama programme
I did see a panorama programme, yes.
at the time that it came out on
At the
television?
time it came out.
And how about Computer Weekly in 2009?
I can't recall whether I read that at the time. I certainly saw it or read about it afterwards, but I don't know whether I read it in 2009.
And am I right in understanding that 2006 and the Carl Page case was the final case that you were involved in that related to the Horizon system?
Yes, it was.
Thank you. I'm going to take you back to your witness statement. It's paragraph 48 that I'd like to look at now, and that's at page 18. It's WITN, thank you very much, page 18. Thank you. You say, at no time that I dealt with post office cases was I aware of any potentially relevant known bugs, errors or defects in the Horizon IT system. Had I known that any such bugs, errors or defects existed, then such an allegation in a defence case statement or defence statement would clearly have triggered an obligation to disclose such information. I just want to look at a couple of words that you've used in that paragraph. First of all, potentially relevant. Are we to read anything into your qualification there about potentially relevant known bugs, errors, or defects?
No, and I have to say, I don't think my response was complete in this. I think, had I been aware there were any potentially relevant known bugs, errors, or defects in the Horizon IT system, then it's something that should have been looked at before charges were brought. I mean, I don't think it would have waited for a defence case statement because it would be clearly something that that could assist the defence.
Thank you very much. That was going to be my second question as to whether you really thought that the defence statement was the correct trigger for disclosure of that information. Can we move on to paragraph 128 of your witness statement? That is on page 37. And you come to some general conclusions or recommendations in your statement. You say at the bottom there, had I been aware that bugs, errors or defects of any faults in Horizon, then clearly a challenge to the integrity of Horizon in one case would be relevant to other ongoing or future cases. It is now clear that Horizon was not the robust system it was held out to be. In my view, no proceedings should have been started unless the Post Office were able to prove that those bugs, defects or faults could not have impacted on the operation of Horizon, i.e. that the evidence being relied on was reliable. Are we to read that as essentially a recommendation for the burden to be placed on the Post Office to prove the reliability of and the accuracy of the figures that they are relying on?
Well, it clearly was.
Yes. And what difference do you think that would have made to the way that you carried out your work for the Post Office?
That's a difficult question to answer because I was under the misapprehension, as it now turns out, that Horizon was operating correctly.
Yes.
I think it would have been very difficult in a Horizon shortage case to actually prove a case if there were bugs in the system. I think as a member of a jury, if you were told that there were bugs that affected, say, Northern England offices, but not Southern England offices, I think a question would arise in anyone's mind as to whether they could be certain that that was the case and that there wasn't an unknown bug.
Thank you very much. That can come down. I'm going to move on to the topic of expert evidence. The inquiry has instructed its own expert, Duncan Atkinson, King's Counsel. I don't know if you saw his evidence, but
I didn't know.
I'm going to take you through some of his evidence as to the rules relating to experts and just see if you agree or disagree with his conclusions in that respect. Starting with instructing an expert, would you agree that the prosecutor must provide an expert with instructions as to the issue or issues upon which his or her opinion is sought?
I do now. I didn't know that at the time. The investigators took all the statements. I think I said in my statement that my understanding was that at the very beginning of this, Dr. Jenkins, I don't know whether he was volunteered or put forward as a witness, but advice was sought on what his evidence would have to cover and what he would be able to do.
We'll get to that. I'll just take you through, I'll try and do it as quickly as possible, all the various conclusions in respect to expert witnesses. Would you agree that the prosecutor must provide the expert with issues or questions which the expert is expected to address or answer?
So yes, but we didn't. We provided, or the investigator provided the evidence effectively.
Would you agree that the prosecutor must supply an expert with material upon which the prosecution relies and which may be relevant to the questions which the expert is expected to answer?
Yes.
Do you agree that throughout the relevant period of horizon-based prosecutions, a prosecutor, or that you were involved in, a prosecutor intending to rely on expert evidence in criminal proceedings was under a duty to, for example, satisfy themselves as to the expert's relevant qualifications and expertise?
Yes.
And to satisfy themselves that the expert had been appropriately instructed, including the provision of written instructions?
Yes, as I said, I thought that there had been a meeting where all of this had been gone through. I didn't independently check that, and I should have.
Perhaps in that case, I'll really skip through all of those conclusions because I think you're very reflective on the situation, and your evidence is that despite the fact that those did apply, you relied on the investigator to satisfy themselves that the expert was appropriately informed and appropriately instructed.
Yes.
Would you agree with Mr. Atkinson and also Rob Wilson to the effect that there was a lack of internal guidelines in respect of the various requirements that applied to the instruction of experts?
Yes, I would.
I'm just going to read paragraph 49 of your witness statement, which addresses this, and that's page 18, please. Thank you. It's the bottom of page 18. You say there, I do not know what information was provided to experts instructed by the prosecution as to their role, including in particular their duty to the court and the meaning and importance of the expert's declaration. The statements were obtained by the investigators. Dr. Jenkins, I think that's a reference to Gareth Jenkins, is it?
Yes, it is.
Yes. Did you know him as Dr. Jenkins?
Yes, I believed he was Dr. Gareth Jenkins.
Dr. Jenkins' statement included the words, "I understand that my role is to assist the court rather than represent the views of my employers or Post Office Limited." Just pausing there, that quote, is that taken from a particular document or is that just your recollection?
I can't recall.
The words are self-explanatory. My recollection is that when Horizon was rolled out, the head of the criminal law team instructed counsel to advise on the expert evidence that would be required and what the statement needed to cover. I believe Fujitsu were then asked who in their company would be able and willing to provide that expert evidence. I do not know what instructions were given. As far as I recall, only Dr. Jenkins provided an expert witness statement in cases I dealt with. I think you would accept that those don't reflect the requirements as outlined by Mr. Atkinson. If we scroll down, paragraph 50, you say, I cannot recall any policies or guidelines in place regarding the provision of evidence by employees of Fujitsu while I worked in the criminal law team. And 51, you say, at the time I believed that Dr. Jenkins was the ultimate expert in Horizon. It did not occur to me that there could be a potential conflict of interest. I do not recall a challenge ever being made by the court or the defence regarding the use of Dr. Jenkins as an expert witness. His role was to provide objective, unbiased opinion on matters within his expertise to assist the court and not the prosecution. Knowing that he was an employee of Fujitsu, the company that was responsible for building and operating Horizon, did you see any conflict of interest or potential conflict of interest in Mr. Jenkins acting in that role?
At the time, no, I didn't.
And now?
Well, now, clearly, I do. Because there was clearly a conflict with Fujitsu generally, because as far as I'm concerned, the fact that there were bugs, etc., were hidden from us.
If we could scroll down to paragraph 86, that's page 30, and it's the bottom of page 30. You say there, I believe that Dr. Jenkins would, and over the page, have disclosed any material which cast doubt on his opinion. Looking back, and I haven't taken you through the specific conclusions of Mr. Atkinson, but would you agree that that doesn't really reflect the duties on the prosecution, effectively subcontracting the disclosure duties to...
Yes, I do.
Yes. Was that because Mr. Jenkins was assumed to know his duties because he had been involved in other cases, or was it for some other reason?
Yes, it was assumed that Dr. Jenkins knew his duties, which is clearly wrong, and I accept that. And it was also believed that he effectively knew everything there was to know about Horizon. So in other words, he would be aware of any issue.
Thank you, that can come down. You've mentioned Mr. Jenkins a few times in your statement. We're going to come to the case of Carl Page, where you mention him, but if we put that particular case to one side, do you recall specific cases where you were involved with Mr. Jenkins?
The first time I met... it's Mr. Jenkins.
It is Mr.
Sorry.
Jenkins.
The first time I met Mr. Jenkins was in the case of Page and Whitehouse. So I'd never had any dealings with him before, although I would assume that I would have seen witness statements from him in previous cases.
When you say you assume you would have seen witness statements, is that because it was well known in the office that he provided those kinds of statements, or was there some other source of that conclusion?
Well, my understanding was he was the only person at that time who provided expert evidence on the operation of Horizon.
And if we look at paragraph 43 of your statement, perhaps we don't need to bring it onto screen because it's a paragraph that we've already looked at, but I think you said that Dr. Jenkins, in his expert witness statement, would have asserted that there weren't any bugs, errors or defects. When you say would have asserted, was that something you recall? Was it speculation or was it something else?
No, it would have been the purpose of his statement would have been to enable the prosecution to prove that Horizon was operating properly and therefore could be relied on.
Were you, well, we'll talk about the Page case. Were you involved in any communications other than that case with Mr. Jenkins?
I wasn't directly involved in communications with Mr. Jenkins. They were all done by the investigator.
Thank you. Before we move on to the case studies, one other topic is identification codes. You've addressed those in your witness statement. You weren't aware of the ID codes document that we know as Appendix 6.
No, I wasn't.
Are you aware that in the event, I think you've said in your witness statement, that in the event of a conviction, certain information was needed by the police that addressed ethnicity, for example? Is that right?
Yes, that's correct.
Are you able to assist us? Were those what are referred to as NPA forms? Is that something you remember at all?
Yes, I believe so.
And they were required for police intelligence databases and also for notification of convictions. Is that correct?
That's correct.
Are you aware of the Post Office collecting race or ethnicity data for any other reasons other than for the police?
No.
Thank you. I'm going to move on then to the case of Carl Page. You're the first witness who is going to address this case, so I'm going to have to read a little bit from the Court of Appeals transcripts just to familiarise the Chair and the inquiry with the particular case. Can we look at poll 00113278, please? So this is the Court of Appeal judgment in Hamilton, Josephine Hamilton and the Post Office. Can we look at page 58, please? It's paragraph 277 onwards in the Court of Appeal. Thank you. So we have there Carl Page, and the Court of Appeal says, on the 15th of November 2006, in the Crown Court at Stafford, Carl Page pleaded guilty to theft. It says that the indicted shortfall was $282,000, and on the 19th of January 2007, he was sentenced to 2 years imprisonment following a basis of plea which accepted the theft of $94,000. Do you have a particular recollection of the ultimate accepted plea being significantly less than the indicted shortfall?
I was aware of that, yes.
We'll probably come to it in due course, but very briefly, can you assist us with why that was accepted? Or why the figures are so dramatically different?
I think that my recollection is the basis of plea was that he accepted that he had stolen £94,000 and the remainder was either due to errors or theft by other members of staff.
Yes, and we'll come to that. That's also mentioned in this judgment. It goes on, paragraph 278. Mr. Page and a co-defendant, John Whitehouse, were jointly charged with conspiracy to defraud and theft. At a trial in the summer of 2005, they were acquitted of conspiracy to defraud, but they were unable to reach a verdict on theft. Mr. Page was retried on his own for theft. Can you assist us? Were you involved in that original trial?
I was, yes.
The Post Office's case at the first trial was that Mr. Page had colluded to steal money with Mr. Whitehouse, who was a customer. That case was not maintained at the second trial, at which the Post Office alleged that Mr. Page had physically stolen $282,000 from the branch and hidden the losses in the foreign exchange system. Then refers to the defence statement for his second trial, and I'm going to take you to that shortly. It says that he denied that he had been dishonest, saying that the Post Office could not prove how much money ought to have been in the accounts at the beginning or end of the indicted period, or when or how the money was taken. The amount of theft in the second trial was reduced to £94,000 following an accepted basis of plea, and this is, I think, what you were referring to earlier. The basis of plea stated as follows: the defendant stole £94,000 from the post office, having begun to do so on return from holiday in August 2002. The remaining deficit of £188,000 may have been the result of incompetent accounting or possibly theft by other persons. The underpinning rationale for that reduced figure is no longer clear. So I think really my question from earlier is the underpinning rationale for that reduced figure isn't clear. We're going to hear from a counsel in that particular case, but do you have any recollection of the underpinning rationale for the reduced figure?
I don't know.
The post office relied on Horizon data to evidence the missing £282,000. Two separate defence expert reports noted that the prosecution case was almost exclusively based on the missing money in Horizon, but the post office argued it was also based on data from the Ford money changer, which is separate to Horizon. We're going to come briefly to look at those defence expert reports. Paragraph 284, the Court of Appeal says the defence experts were critical of the post office audit and the conclusions to be drawn from it. One of the defence experts expressed the opinion that the shortfall could be attributable to unidentified errors in Horizon and noted the high incidence of errors in the system. The expert disagreed with the prosecution assertion that the shortfall automatically amounted to theft without further evidence. It says there is nothing in the post office's case papers to indicate that any ARQ data was obtained at the time of the criminal proceedings. There was no evidence to corroborate the Horizon evidence. There's no proof of a natural loss as opposed to Horizon-generated shortage. We also regard it as unsatisfactory, to say the least, that Mr. Page was subjected to cross-examination in the first trial on the basis which the post office felt unable to sustain thereafter. And then the Court of Appeal concludes that it was not only unfair, but they also conclude that the prosecution was an affront to justice. Thank you. That can come down, please. Can we return to paragraph 65 of your witness statement, please? That's page 25. It's WITN 089000100. Thank you. Page 25. There's a reference to paragraph 65 to the first trial, and it says Stephen John made the charging decision in this case. Mr. Page and Mr. Whitehouse were jointly charged with conspiracy to defraud, and Mr. Page was additionally charged with theft. We spoke earlier about who makes the charging decision. The suggestion in your statement there is that it is prosecuting counsel. I think Stephen John was prosecuting counsel. Wasn't
Yes, he was.
But did you mean that Stephen John made the charging decision in the case?
Well, Stephen John advised that there was sufficient evidence to afford a realistic prospect of conviction and that it was in the public interest to prosecute.
I think really my question is, was it sometimes unclear as to who ultimately made that charging decision?
So my view, when I was involved in this case, was that Stephen John made the decision to charge.
Was it sometimes effectively delegated from whoever was responsible at the non-legal level at the post office to, for example, counsel in the case?
Yes.
I think you say at paragraph 67 you can't recall who authorised the prosecution of Mr. Page.
No, I can't.
Again, might it have been you, or is this somebody who was not?
No, I wouldn't have authorised the prosecution. It would have the papers would have gone to casework, who would have forwarded them to the authorisation manager.
Thank you. Well, I'm now going to go through as briefly as I can, the three expert reports in this case, two from the first trial and one from the second trial. Can we begin with poll 000458867, please? This is the expert report from the first trial, 16th of May 2005. This was obtained by the defendant, Mr. Page. Is that your recollection?
Yes.
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 Is this something that you would have read at the time?
Yes, I would have.
Can we please look at page 5? I'm just going to read a few paragraphs from this report. It's the bottom of page 5, 2.6. The expert there says, on the matter of the theft charge, the key question is whether Mr. Page could have built up a significant AM stock of euros of around 456,000 euros, which the prosecution alleged that he stole. I've examined the evidence of the deliveries of euros to Rugeley Post Office throughout the indictment period and compared them to the payments by Mr. Whitehouse for euros and a normal underlying level of euro sales, and the FM Command 10 printouts of all euro sales by Rugeley Post Office. Just pausing there, it is a very complicated case, and I don't expect you to recall all of the detail from this report. I'm going to ask you some very general questions about the report itself. Paragraph 2.7, both these analyses indicate that a surplus of euros, or approximately 456,000 euros, could not physically have been built up in the AM stock or elsewhere. All the euros delivered to Rugeley Post Office were entered into FM, and my analysis shows that sales of these euros match or exceed the deliveries. This contradicts the findings of Mr. Manish Patel, which form the basis for the theft charge against Mr. Page. Pausing there, did you know Manish Patel?
Yes, I did.
Did you have any concerns about the work that he carried out in this case or more broadly?
No, I didn't. And the expert appears to have misunderstood the prosecution case. The prosecution case was precisely that these euros couldn't have built up in the AM stock or elsewhere because all the euros could be proved by the prosecution to have been sold, and that effectively the euros have been inflated in order to cover the shortage that was in the accounts.
Thank you. So this report goes on to say, I've also considered the possibility that timing differences account for the alleged shortfall of AM stock that is set out in Mr. Patel's schedule. I've identified the possibility that a delay between the date of sales of euros to Mr. Whitehouse were entered on FM and the date he physically collated the cash could explain the calculation of the alleged discrepancy. And this is the final paragraph I'm going to read to you from this report. It says, the prosecution have relied on evidence of a difference between the amount of foreign currency recorded on the Horizon system and the amount shown on FM in support of their assertion that a surplus of £282,000 of euros built up and was stolen by Mr. Page from Rugeley Post Office. It is my contention, based on my analysis of the deliveries and sales of euros, that no such surplus of euros existed. I'm now just going to take you to the second of the expert reports in the first trial. That's poll 000458868. It's by the same expert, dated the 17th of June 2005. And it's page 8 that I'd like to go to. Auditing methods used by Royal Mail. He says there reference is made throughout the prosecution witness statements to audit work carried out at Rugeley Sub Post Office by Royal Mail staff. I have serious reservations that the work carried out did not constitute an audit in the sense that data was not verified back to source documentation, nor critically examined before conclusions were drawn. I've carried out only a limited review of the audit schedules disclosed to me, but I have identified two serious shortcomings that indicate the work carried by Royal Mail was more akin to a stock take than an audit. As such, the findings of that work cannot be relied upon to the same extent if they were derived from audited figures. Just pausing there, do you recognise the criticism that what the Post Office may have referred to as an audit was in fact more akin to a stock take?
Yes, I would accept that. I think the witness statements made it clear that it was effectively a stock take that was being done. I don't think there was any suggestion in any witness statement that it was anything other than that.
But more broadly, looking at other cases and more broadly the conduct of the Post Office, what they called an audit wasn't what would generally be understood as an audit. Do you agree with that?
I accept that, but I don't think any witness statement would suggest it was anything other than effectively a stock take. They would print out the horizon, was it a snapshot that showed what should be present, and then they would go through all the documentation and count the cash, etc.
By the sound of it, this doesn't sound like a case where ARQ data, for example, was audited.
Sorry, can you say that again?
By the sound of this expert report, it sounds as though something like ARQ data from Fujitsu wasn't obtained and audited, because that would constitute more of a formal audit. Do you agree with that?
I agree. I can no longer recall whether ARQ data was obtained, but I would accept that it wasn't, as there's no reference to it.
If we look at 2.29, it says, I've seen no indication in the witness statements in this case that any audit or verification work was carried out on the balances at the 8th of January 2003. If that is the case, then the Royal Mail cannot be certain that that those balances are correct, and consequently cannot be certain of the amount of the overall audit result, etc. I don't think I need to take you to much more of this. Because obviously Mr. Page was acquitted in relation to this trial, and it's the second trial that I'll focus on.
Absolutely. Can I just say that because the judgment that we've just read, unless I'm misinterpreting it, but it suggests, if I'm reading it right, that Mr. Whitehouse was also charged with theft, and there was a link between that and the foreign currency trial, if I can call it that. Mr. Whitehouse was never charged with theft, and they were two totally distinct set of facts.
Yes, but the second matter wasn't proceeded with at the time of the first matter. The Post Office seems to have waited until he was acquitted of the first trial to then consider whether it proceeds with the second trial.
Sorry, I don't follow.
Were the facts on which the second prosecution were based available to the Post Office at the time when the first trial took place?
I haven't seen the opening note in the second trial, but my recollection is the facts that were put forward were the same, that the theft charge relied on the audit shortage, the £282,000 that couldn't physically have been in the foreign currency, and that it had been hidden by inflating the foreign currency on hand. That had been the case in the first trial and was the case in the second, although in the second trial, one of the key differences was that we had found evidence to show that an earlier audit, where I think there was a shortage of something like £8,000, should have in fact been over £100,000, because a cheque that had been taken into account actually shouldn't have been.
Let's look at the defence statement in that case, which clarifies some of the issues that were between the parties. Can we look at UKGI 000122306? So this is the defence statement from the second trial, April 2006. And can we turn to page 2? I'm going to read a couple of paragraphs from that defence statement. If we begin, I'll begin at paragraph 2. The defence here say, the Crown asserts that Mr. Page has stolen £282,000 from the Post Office, Curiously, the Post Office cannot say when the money was stolen, nor by what means, nor from what account or fund within the Sub-Post Office. From January 1993 until July 2005, when Mr. Page and a Midlands businessman, Mr. Whitehouse, were acquitted of conspiracy to defraud the Post Office of £600,000, the Crown's case generally was that the money had come from the foreign exchange till. Having thought about it and having accepted the verdict of the jury, the Post Office now suggests that a separate amount, which has nothing to do with the £600,000, has been stolen by Mr. Page from somewhere else in the office, but hidden by some means in the foreign exchange account using the Post Office's Horizon computer system. However, for reasons identified by Mr. Timothy Taylor, FCA, in his expert report, and that's a report that we're going to come to, of April 2006, this is extremely unlikely because of what the Post Office itself found when it examined the accounts. And I'll just read paragraph 3. The defence statement says, "It appears to be the case that the entire accounting system of the Post Office relies on the accurate inputting of information by the on-site staff who send the weekly returns off by post to various centres. Thus, once an input error is made, because of the way the system works, there's a serious danger of it being carried forward forever. Although the indictment period runs from the 1st of March 2002, the Post Office does not know whether the opening balances are correct and has no way of knowing what the real as opposed to the inputted figures are or should have been. It is a significant feature of the case that in the middle of the indictment period, a Post Office audit team went to Rugeley, closed the office and audited the entire operation. They concluded that the office was not well run, but did not find evidence of theft or fraud." I'm going to now turn to that expert report that is relied on. That can be found at Pol 000061214. And this is an expert report that's been obtained from KPMG, Mr. Taylor, dated the 7th of April 2006. Would you agree that there is contained within this expert report an attack on the Horizon system?
Absolutely.
If we could look at page 21, please. We'll just have a look at those conclusions. I note the following. I agree with Mr. Patel that as from the week ended the 28th of August 2002, the Horizon foreign currency sterling equivalent figure was inflated initially by 138,000. I agree with Mr. Davies that on the basis of the accounting evidence available, the shortage of the audit on the 27th of June 2002 should have been increased, and gives the amount. The alleged deficiency of 282,000 in the AM stock unit does not necessarily indicate theft by Mr. Page. Any such shortfall could in practice be the result of other identified errors or deficiencies, or differences in Horizon. It is implicit in the prosecution's case that by simply stating that the 282,000 shortfall equates to a theft of the same amount, all other figures in Horizon, except for the differences identified at the audit, were correct. I've seen no evidence that this is the case, and would also note the high incidence of errors as set out in section 5.7. The prosecution rely on the assumption that the figures in Horizon are those recorded by Rugeley Post Office staff themselves, and that the Horizon system was working correctly throughout the indictment period. It is now not possible to establish whether the declared ONCH figures were correctly recorded in Horizon, as they were not independently checked at the time, other than at the two audits. It's alleged that by the week ended 31st of July 2002, the theft had reached 177,500, and that it was being concealed by either overstating the true foreign currency balance or the ONCH figure. Then, in my opinion, there is an unexplained inconsistency in the prosecution's case. This is because the 2 weeks, and gives the 2 weeks, the inflation figures, as stated by Mr. Patel, are nil, and recorded ONCH figures were only £79,000 and £91,000 respectively. and therefore they could not be overstated by £177,500. Looking back at this case, if you had known that Horizon was not as you thought at the time, would you have acted differently on receipt of this report?
If I had known that Horizon could contain bugs, errors, defects, then it wouldn't be a question of acting differently on receiving this report. It would have been a case of looking at the evidence differently at the beginning of the first trial, because, as I said, the evidence was based on the Horizon shortage at both trials. So it's horrendous that we didn't, and it's horrendous that Mr. Page faced a second trial on the same evidence. And I can but apologise to him.
Thank you. Can we just look back again at your witness statement? I've very nearly finished with this case study. Just returning to your witness statement at paragraph 70, and it's page 26. It says in the middle of that paragraph, Glyn Burrows, in his statement, outlines what he and his team did in conducting the audit. He explained that he would request an office snapshot printout from Horizon, which provided a summary of all the cash and stock which should have been present at the office at the time, together with a summary of all receipts and payments in relation to transactions conducted at the office at the beginning of business, and gives the date. Are you able to assist us with why it seems as though ARQ data did not form part of any analysis here, and reliance was being placed on office snapshots?
I'm sorry, but I can't. I know we had a witness statement from Mr. Jenkins, which I haven't had sight of, and whether he produces anything, I don't know. But we clearly should have obtained it, and I would accept from what's been put here that someone's looked at all the unused material and that we didn't. And I would have thought, had we, the expert would have referred to it.
Thank you.
As in the defence expert.
Just finally, in relation to this case study, you've mentioned Mr. Jenkins. There's mention of Mr. Jenkins in your witness statement in relation to this case. We don't have, or we haven't been able to obtain a report from Mr. Jenkins, a statement from Mr. Jenkins in relation to this particular case. How confident are you that he did feature in this case?
I'm 100% sure.
And can you assist us with your recollection of the level of his involvement?
So I can't, but I do recall him giving evidence at court. It was the first time I'd actually heard an expert witness give evidence on Horizon, so I do recall it.
Is there anything?
But I don't recall the content, but it was a long time ago.
What was your understanding of his particular role in those proceedings?
To prove that Horizon was operating correctly and that the figures could be relied on.
Thank you very much. Sir, there are two other case studies that this witness was to some extent involved in, but very little. I don't have very much more to ask, but we have plenty of time this morning. Perhaps that is an appropriate time to take a 15-minute break.
Well, we will do, but let me just ask one or two more questions about Mr. Page's case, just to ensure that I understand fully what Mrs. Stapel is saying to me. So far as what happened procedurally, Mrs. Stapel, the question I ask you is, have I got this right? All right.
Right.
The first trial involved both Mr. Whitehouse and Mr. Page.
Yes, it did.
On count one, they were both charged with conspiracy, but there was a second count exclusive to Mr. Page, and he was charged with theft.
That's correct.
So when we've been talking about a first and second trial, theft was always on the indictment in the first trial.
It was, yes.
And my understanding is both men were acquitted of count one, but the jury couldn't agree on the theft charge against Mr. Page.
That's correct, sir.
And that's how the second trial came to take place, not because they were separated, it was a retrial.
Absolutely.
Right, fine. So going to Mr. Jenkins's role, if, as you asserted, he gave evidence, it must have been in the first trial because the retrial didn't take place.
No, absolutely.
And so if there is a witness statement and if Mr. Jenkins gave evidence, it's the first trial that we need to focus on.
Absolutely.
But his role in the first trial would have been, as you've said, to give evidence about the reliability of Horizon. And that related to count two, Mr. Page's, the allegation of theft against Mr. Page. Is that right?
Indeed, sir.
So it was directly relevant to whether or not Mr. Page was guilty of theft.
It was.
Thanks. I've got all that clear. Thank you very much. We'll have our 15-minute break now.
Thank you very much, sir. If we come back at 35 minutes past.
Fine. Thank you.
Thank you. Thank you, sir. Can you see and hear me?
Thank you, yes.
Thank you. Just two very brief topics, two case studies. The first, Mrs. Edidayo, and the second is Ms. Rudkin. Starting with Mrs. Edidayo, we have heard about this case study from another witness, so I'm not going to ask you very many questions at all about this case. She is in attendance today. I think you've said in your witness statement you have very little recollection of this particular case. Is that correct?
Absolutely.
The one document that I'm going to take you to is the charging advice, and that's at poll 000444361. So this is an advice, I think, from you on the sufficiency of evidence, and I think you advised on the sufficiency of evidence and made the charging decision, or are we in this?
Yes, I did.
Yes, thank you. And why was it sent to Ms. Natasha Bernard?
Sorry, can you repeat the question?
Can you assist us with the recipient? And
Oh, I see. I'm sorry. Yes. So basically, files will be submitted via the casework management team to us, and our response would always be to the investigator.
Thank you. If we look down the page, it starts by saying, in my opinion, the evidence is sufficient to afford a realistic prospect of conviction of the above named on the charges set out on the attached schedule. And third paragraph says, in view of the serious breach of trust involved in this case and the amount of money borrowed by the defendant, this offender should be prosecuted. We've spoken about the Code for Crown Prosecutors. We've spoken about the full code test and the difference between the evidential test and the public interest test. Is there anything here that addresses the public interest aspect?
No, so simply that obviously in addressing the public interest, you have to look at whether there factors whether factors against prosecution outweigh those in favour, and basically in this case there weren't. So I deemed it to be in the public interest because of the breach of trust and the amount of money that had been borrowed.
Is this typical of a charging decision relating to this kind of a case where you won't see, for example, a separate paragraph addressing public interest?
Yeah, this would be quite typical advice.
Thank you. Could we look at paragraph 109 of your witness statement? It's WITN 089000100. And it's page 35, paragraph 109. I'm just going to read part of that paragraph because, as I say, Mrs. Adedayo is in attendance today. And it says, I have considered the transcript of Mrs. Adedayo's evidence to the inquiry. At the time I advised on evidence, there would have been nothing in the papers to indicate that anything untoward had happened on the day of the audit and interview. I was not present on that day, so do not know what occurred, and it would therefore be inappropriate to comment, save to say that on Mrs. Adedayo's evidence, her interview would have been ruled inadmissible. Her account of the impact that the prosecution had on herself and her family are truly heartbreaking. And that's your evidence to the inquiry in respect of this case.
That is my evidence. I mean, her account was truly heartbreaking, and I hope the Post Office have now paid the compensation to her.
Thank you. The final case study is Susan Rudkin. We're going to leave that for another witness because I don't think you had any direct involvement in the prosecution. I think you've said that you just followed up afterwards on notifying the relevant...
Yeah, I just notified the result of one of the hearings, but I wouldn't have read the file in order to do that. It would have simply been responding to a memo.
Thank you very much. Sir, those are all of my questions. We do have questions from Ms. Dobbin and Mr. Steen. Can I propose that we take them in that order?
Yes, by all means.
Thank you.
Can you hear me now? Yes, it's on now. Thank you. Sorry, Ms. Stapel, I don't know if you caught that. My name is Claire Dobbin and I represent Gareth Jenkins. I just wanted to check some points with you, if I may. First, is this right? Aside the 3 cases that you have been asked about in your witness statement, you can't recall any case that you had conduct of which depended on or relied upon a discrepancy in the Horizon system. Is that correct?
I can't recall any individual case, no.
And is this also right, that after 2006, you did not, in fact, have conduct of any of those types of cases, with the exception of Mr. Page's case?
That's correct.
Is that also correct? And I think it's right from what you've said today that, in fact, there was no case in which you instructed Mr. Jenkins as an expert, save that you think he was instructed in the case of Mr. Page. Is that also right?
There was no case where he gave evidence in court. I can't recall whether he gave a witness statement in any other case I dealt with.
Right. Well, let me see if I can explore that a bit further. Can you, in fact, recall any other case at all by name in which you obtained a witness statement from Mr. Jenkins?
I can't recall, no.
Can you recall anything about such a case?
No, I can't.
Can you recall even the geographical location of a post office or any sort of detail like that in such a case?
No, I can't.
So is this right? You can recall absolutely nothing about any case in which Mr. Jenkins was involved, aside the case of Mr. Page. Is that right?
Yes, if I had been asked to outline the facts of the case of Page and Whitehouse without being given sight of these documents, I would have been unable to do so. It was a long time ago.
I understand that, but I'm asking you for any information whatsoever about any other case in which you were involved.
Yes, I cannot recall.
Mr. Jenkins was involved.
Yeah, I cannot recall any other case where Mr. Jenkins was involved.
And when I refer to Mr. Jenkins having been instructed by you in the case of Mr. Page, Again, as I understand your evidence, what you're saying is that, in fact, if he was instructed, it would have been by the investigator rather than you. Is
Absolutely.
that right?
I had no direct contact with him.
And in that regard, you had no concept whatsoever of the duties of a prosecutor in relation to an expert. Is that right?
I've already said I failed in that duty, yes.
The question was whether or not that means you had no concept of the duties that a prosecutor bears towards an expert.
No, because otherwise I would have sent the letter of engagement and, yeah.
And given that those duties were enshrined in common law and that duties were also set out in the criminal procedure rules from around 2006, can you assist the inquiry as to why you didn't know you had such duties towards an expert witness?
So the 2006 rules would have been after I ceased doing the poll cases, and I don't know what the earlier rules said.
But does that mean then that you didn't keep abreast of developments in common law?
No, but
or
I
in civil
didn't.
procedure rules?
I didn't
Criminal
use an
procedure rules?
expert in any case after that.
Beforehand?
Sorry, beforehand?
I'm just trying to understand whether or not you would have kept abreast of developments in the criminal procedure rules or in the common law.
Yes, we would have. So I can't explain why we dealt with experts wrongly.
You refer throughout your witness statement to Mr. Jenkins as Dr. Jenkins. He's obviously not referred to that in any witness statement because he's not a doctor. Can you explain why you think he's called Dr. Jenkins?
No, I can't. As I think I said earlier, a copy of his witness statement wasn't in the bundles, and I just thought he was called Dr. Gareth Jenkins. I can't explain that. Clearly, I made a mistake.
Can I ask you, please, about paragraph 49 of your witness statement? I wonder if it would help, please, if we could bring that up. Do you have that in front of you, Miss Stapel?
I haven't got paragraph 49. I can look it up in here if you'd like,
Please, if you would.
but it hasn't come up on my screen.
It's page 19 of your witness
Oh, it has
statement.
now.
Just looking at the top of that page, Miss Stapel, you say, and this is the second sentence, Dr. Jenkins' statement included the words, and we can see that these are in inverted commas, I understand that my role is to assist the court rather than represent the views of my employers or Post Office Limited. So it does look as though you are quoting from a document. Can you assist me, please, as to what document you were quoting from?
I can't now, I'm afraid.
You signed this witness statement relatively recently.
I did, and I looked at a lot of documents.
Did you see any statement from Mr. Jenkins?
No,
as
I didn't
part
see
of
any
the-
statement from Dr. Jenkins.
Can I ask whether or not you have seen a document called the Clark Advice?
I have, yes.
Is it from the Clark Advice that you're getting information like this?
It may be.
That makes absolute sense, doesn't it, Miss Stapel?
Sorry, what makes absolute sense?
It makes sense that this is where you're getting information about Mr. Jenkins being referred to as Dr. Jenkins and where you're getting information about what he said in his witness statements.
It may be.
I'm going to turn, please, if I may, to the case of Mr. Page. Can you tell me, please, if you agree with me about this? In all of the material that's been provided to you by the inquiry, you've seen no report by Mr. Jenkins in that case?
I haven't, no. I've only been provided with part of the evidence.
You've seen no witness statement from him?
I haven't, no.
He's not mentioned in any opening note. Is he as featuring in the trial?
I don't believe so.
He's not mentioned in the defence case statement as featuring in the trial or in the case, is he?
I don't believe so.
He's not mentioned in any expert report, is he?
I don't believe so.
He doesn't feature in the 109-page bundle of witness statements that were provided to you by the inquiry at all, does he?
No, but the witness statements that I've been provided with are incomplete.
Incomplete in that only Mr. Jenkins' witness statement is missing from it?
No, the bundles were vast. As I said, I can only remember that Mr. Jenkins gave a witness statement because I can recall him being in court.
Well, can we turn to that, please? Please may I ask that the document POL 000067102 is brought up. Can you see that, Miss Stapel?
I can, yes.
Can you see that it is a letter from you?
I can, yes.
And can you see it's a letter from you asking the defence to confirm all of the witnesses that they wanted
yes.
to give evidence at the trial?
I can, yes.
And it's a long list of witnesses, isn't it?
It is, yes.
And is Mr. Jenkins' name on that list of witnesses?
No, it's not.
No. Thank you, Miss Stapel. Those are my questions, sir. Thank you.
Thank you, Ms. Dobbett. Mr. Steen.
Is it Mrs. Stapel or is it Ms. Stapel?
It's Mrs.
Mrs. Stapel, my name is Sam Steen. I represent a very large number of sub-postmasters and mistresses, and I've just got a few questions for you. Touching upon one matter that you spoke about today when speaking to Mr. Blake earlier on, you discussed with him the fact that you learnt about possible errors and defects in the Horizon system, and you were discussing with Mr. Blake the Computer Weekly magazine, yes?
Yes.
Now, he then said, well, the Computer Weekly magazine article started in around 2009. So would it be in around 2009 that you started to learn about these issues being discussed in the press?
I believe so. I couldn't be certain of the date, but I believe so.
Okay. Now, when we think back, Mr. Stapel, to your time at the post office, you left, unless I got this wrong, in 2013?
I did, yes.
By the time you left in 2013, what was your role? What were your duties at that time?
I was solely advising on Royal Mail cases, so cases dealing with postmen.
Right, okay. The issue, which is problems with the Horizon system, being brought to your attention in 2009, must have been of some interest to you. Do you agree?
I would agree.
Because you've come across today as being somewhat, if I call it somewhat annoyed, you might put it slightly higher than that you weren't told that there were issues with the Horizon system. Is that fair?
That's fair.
How annoyed are you? Between a bit, of concern right the way through to livid.
I think it defies belief, what happened. I think it's unbelievable that even at the rollout stage, people were aware that there were technical issues and they were kept hidden. I just think it's outrageous, the suffering that's been caused by that.
From your point of view, as a lawyer working within this system, how do you feel about being denied this information?
How do I feel? I feel that I thought I was advising fairly and competently, and I wasn't in the poll cases, and I think it's quite devastating.
In terms of the team that you work within, who was your line manager or line managers?
So to begin with, when Horizon was rolled out,
Yes.
so to begin with it was Mike Heath, and after that it was Rob Wilson.
Right.
Can I just say, I mean, it may not be relevant or not, but in terms of the line of questioning,
Yes, Mr. Stapel.
that when I changed to doing cases involving postmen, I was working at home, so I only came into the office once or twice a fortnight. So I don't know what discussions were going on with the lawyers that were dealing with poll cases during that period. I wasn't party to them.
Right. Okay. Well, that does help, Mrs. Stapel. My last question on that section was going to be that once you learnt in the press around 2009 that there were suggestions being made there, pretty clear suggestions that there are problems with the Horizon system, who did you discuss that with?
I discussed it certainly with Mr. Wilson.
Right. What did he say?
He was of the view still that there were no problems with the integrity of Horizon.
Can you help us a little bit more with that? Because this is a Computer Weekly magazine. It's not, forgive me for putting it this way, it's not The Sun. It's a magazine that's concerned with computers, setting itself out to explain that there's a problem with the Horizon system, referring to the post office. These are quite serious issues being raised against
Absolutely.
a public company like the post office. Did you say in your discussions with Mr. Wilson that,
I know that he held or was involved in meetings with different people across the business, but I'm not sure what the contents of those meetings were.
Now, I'm going to refer you to a document that hopefully we've put forward to the inquiry in terms of the questions I'm about to ask you. So hopefully you've had an opportunity to see it. The document references FUJ 000 81584. Right. Mr. Stapel, it's come up on your screen. Now, this is, you'll see at the top of this page that there's a reference to receipts, payments, mismatch, issue notes, okay? Now, the date of this document is certainly 2010. We're not entirely certain which part. We think it's around August 2010. There are various reasons why we say that we've looked at in relation to this document before. Now, can we just have a look, please, at the attendees of this particular meeting? Okay, attendees going down from the top. We've got Antonio Jazam, Emma Langfield, Alan Simpson, Julia Marwood, Ian Trundle, and then Andrew Wynne. Did you know any of those?
Did I know any of these
Yes.
people? No. So Alan Simpson's name is familiar, but I can no longer recall what part of security he worked in. But none of the other names. Obviously, I recognise Gareth Jenkins' name, but none of the others.
I was going to move down to the next section, which are all Fujitsu individuals: Mike Stewart, John Simpkins, Gareth Jenkins, and Mark Wright. Okay. Now, you've been asked a number of questions about Mr. Jenkins. How frequently sorry, that's a bad question. Let's start it again. Mr. Stapel, how often had you met Mr. Jenkins?
Well, I believe I met him for the first and only time at court in the case of Page and Whitehouse.
Right. Okay. And in your dealings with him, in discussions with him about that case, did he ever say to you, look, there are bugs and there are difficulties with the system? Something like that, just to indicate to you, look...
Absolutely not, and I don't believe I had any discussion with him.
Should we just roll back on that one then? Did he indicate to you whether there were problems with the system? The answer is no. Did you ask him about any issues with the system?
No, that was the purpose of any witness statement, to cover that.
Right, okay. Now, we're going to have just a look at this document. Can we go to bottom of, let me see, yes, bottom of page 2, please. and then we can highlight where it says impact, the 5 bullet points that you can see. Now, Mr. Stapel, I hope that you can see this document okay. So this essentially is a document that is concerned with a bug within the system. And this is the impact of the bug. So we can just go through that. I want to ask you then a couple of questions. So the impact of the bug in the Horizon system is that the branch has appeared to have balanced, where in fact they could have a loss or a gain. Our accounting systems will be out of sync with what is recorded at the branch. If widely known, could cause a loss of confidence in the Horizon system by branches, potential impact upon ongoing legal cases where branches are disputing the integrity of Horizon. It could provide branches ammunition to blame Horizon for future discrepancies. Now, I've gone through that, but this is quite important information.
It's dynamite, yeah.
What, rather than me asking the obvious question, why is it dynamite? Well, in your view, what's your?
Well, firstly, clearly no one from legal services was involved in this. I don't know whether they found out about it afterwards, but it's just extraordinary that any problem with Horizon would be kept from any sub-postmaster or any branch. And the suggestion it might have a potential impact on ongoing legal cases suggests that the people who are involved in this knew that the information should have been relayed both to the criminal law team and civil, and it would look as if this was being hidden. But clearly the whole basis on which the post office operated was that the accounting system could be relied on. It's just extraordinary. And it makes one wonder how many other meetings with similar problems took place over how many years. But I mean, this is clearly something that should have been disclosed to both the criminal law team and indeed the defence.
Early in your evidence today, when you were discussing matters with the first barrister that asked you questions, Mr. Blake, you were talking about being told that the system was a super system.
I think those were my words. I was told that it was, yeah.
Yeah. That was your interpretation of what you were being told.
That was my interpretation
I understand
of what I was being told.
And that, as you've confirmed with me, that the question of bugs, errors or defects was not shared. Absolutely not was your words.
Absolutely not.
All right. You also explained that in relation to a jury or a court, if hearing about these problems, it would undermine such cases, yes?
Certainly if I was a juror and heard there were bugs anywhere in the system, I'm not sure I would convict on the basis of a Horizon deficiency.
Were you aware that it was possible to amend the accounts in a branch? In other words, remotely amend?
Absolutely not, no.
Did you learn at any stage later on, through any of the news about it, or perhaps reading the judgments in the High Court, did you learn later on that it was possible to amend the counter branch's accounts?
I did read that, but I'm not sure where. But that was something that we were assured couldn't happen.
Who assured you it couldn't happen?
So my understanding was that Mr. Heath and Mr. Wilson indicated that was kind of something that was in stone, that no one would be able to access a sub-postmaster's accounts. Or rather, the Horizon information in the accounts.
Now, can we go to page 3 of this document, please? And you'll see there, Mr. Stapel, that under the heading Proposal for Affected Branches, if we can highlight that, Proposal for Affected Branches, very grateful. And then thereafter, you can see there's discussion within this meeting. There are 3 potential solutions to apply to the impacted branches. The group's recommendation is, in fact, solution 2 should be progressed. Now, I'm just going to go through solution 1 with you, because I want to ask you a couple of questions about this issue of remote access. Solution 1. alter the horizon branch figure at the counter to show the discrepancy. Fujitsu would have to manually write an entry value to the local branch account. Impact. When the branch comes to complete next trading period, they would have a discrepancy which they would have to bring to account. Risk. This has significant data integrity concerns and could lead to questions of tampering with the branch system and could generate questions around how the discrepancy was caused. This solution could have moral implications of post office changing branch data without informing the branch. Okay?
Yeah.
Now, just reminding ourselves, as we looked at in relation to the attendees, we've got people from the post office attending this meeting and Fujitsu attending the meeting. So it's a mixture of those two companies, if you like, okay? And reminding ourselves that the date that this particular document is being circulated is in 2010, okay? So, 3 years before you left the company.
But I was no longer doing this type of work then.
Yeah. You've reflected on the question of a jury learning about bugs, errors, defects, and the like, and the fact that if you were on a jury, you wouldn't convict in such circumstances. The situation whereby the accounts can be altered remotely without branch accounts, what's your concern, if any, about that?
Well, that clearly would also have a huge, well, it would undermine the case for the prosecution. I mean, this document is just extraordinary. I mean, the only correct thing to do would have been to inform all the branches involved about the bug and deal with it that way. So it's another sad example of how things were concealed.
In the criminal justice system, there's a process that's used called abuse of process. You're aware of that?
I am aware of that.
It's got, I'm sure you'll recall, I know you do other work now, but it's got 2 limbs to it, which I can loosely call that where something has happened that's so bad that no case should be prosecuted, and the second limb whereby it's unfair to prosecute a case, okay?
Absolutely.
In relation to prosecutions that were ongoing at around this time, do you think this sort of material should have been disclosed so that matters such as that could be considered?
Of course it should.
Excuse me one moment, Mrs. Stapel. Thank you, Mrs. Stapel. So no further questions.
Thank you, Mr. Steen. Are there any other questions from anyone?
No, sir.
Oh, thank you very much for coming to give evidence. Firstly, well, sequentially, thank you for making a detailed witness statement in response to the questions you were asked. And thank you for coming to give evidence today. I'm obliged to you. So, Mr. Blake, we carry on tomorrow with Mr. Tatford, is that correct?
Yes, that's correct, sir.
Fine. 10 o'clock tomorrow morning then.